Welcome, Facebook Live viewers. Thanks for tuning in again for another episode of the Bond and Botus Facebook Live that we've been doing since COVID really set in, with a lot of folks staying home. Just as a reminder, I'm Brad Botus with the Bond and Botus Law Offices. We have offices throughout Alabama, Mississippi, and we're in the Knoxville area in Tennessee. And at Bond and Botus, we help people with financial problems. And there are a lot of people having financial problems right now. We want you to know that during COVID, we are offering absolutely free initial consultations where you can just reach out and get some information and advice from an experienced bankruptcy attorney. And we're doing the consultations from the safety of your home or office. We'll do them by phone or video, however you feel comfortable right now. But we encourage you to be proactive and reach out for advice right now. Don't let things happen to you. Reach out and be prepared to deal with financial matters that are before you. We're fortunate today to have my good friend and board certified attorney, Erik Clark, excuse me. Erik's with the Borowitz and Clark Law Firm, which is one of the largest consumer bankruptcy firms in California. Erik's a board certified attorney, very experienced, and he's here today to join me to talk about a topic that's very important to both of us. So Erik, thanks for joining us today.
Thank you, Brad, for having me. It's a pleasure to be here with you today.
So Erik, a lot of our viewers don't know you. Can you just tell us a little bit about your background and experience, please?
Sure. I've been a bankruptcy lawyer for the last 25 years. As you stated, I'm a board certified bankruptcy specialist here in California, also licensed in New York and Connecticut. I have been a owner of Borowitz and Clark, the law firm, for the last 22 years. We just celebrated our 22nd birthday yesterday.
Wow!
And
congratulations.
We've helped about 40 or 50,000 people through the bankruptcy process throughout that 22 years. And we love what we do. And in addition to that, I'm a father of four and just had a baby 3 weeks ago. So we're busy here at the Clark House.
That's awesome. Congratulations to you and your family and your law firm. You know, you have helped a lot of people with bankruptcy throughout the years. Bond and Botus, we've just passed 31 years now of helping people with bankruptcy matters. But, you know, I think it's important for people that reach out to both of our firms to know that we don't really just focus on bankruptcy. We want to help people with money problems. And if bankruptcy is the right option, I'm sure your firm is like ours. That's what you'll do. But we just want to help people face their money problems. We want people to know that there are good options out there. And there are a lot of people having money problems right now.
Sure.
But Erik, we're here today to talk about something that affects your clients in California, our clients in the Southeast, and that's the debt consolidation, or debt negotiation programs. We hear a lot about them, commercials that sound real good, usually late at night on television. But why don't you just give us, I know you feel passionate about this issue, why don't you just give us a quick overview of what we mean, what debt negotiation or debt consolidation programs are?
Sure. Yes, you're right. The slick ads come on late at night when most of us are up, and certainly people facing financial distress are up worrying about what they're going to do about it all. And across the TV flows this ad that says, you know, we can solve all of your problems with the wave of our magic wand. And often, you know, in hindsight, certainly it sounds too good to be true. But at the time, you know, people going through these financial problems are vulnerable and they're looking for an answer. And often these ads are very effective. So it is important to understand what they're talking about, though, because they often talk about secret ways that the credit card industry doesn't want you to know about. And all of that, quite frankly, is nonsense. There's no real secrets here. And to the extent that they are secrets, we're here today to dispel and tell what those secrets are. Yeah. When we talk about debt negotiation, or let's start with debt consolidation. When we talk about debt consolidation, there's really two different ways of consolidating your debt that most people deal with. The first being going out and getting a consolidation loan, which is where you just borrow the money. So if you owe $15,000 across, say, 5 credit cards, you go out and get a new $15,000 loan, and it'll be usually at lower interest than you're paying on the credit cards. You pay off the credit cards, so those show real nice on your credit report because they've been paid in full. But now you have this new loan, and you really are it's the old shell game where you're sort of moving the money that you owe around. You're not really solving the problem. You're just, now you've got a new loan, maybe at a little lower payment, but typically you're continuing to struggle to make that payment. And that's
a term we use in the South, Eric, and I don't know if you use it there, but it's hard to borrow your way out of debt.
Yes.
And that's often what you're doing there.
Exactly. And then what happens is the credit cards are all paid off. So then when times get a little tough, then you have the tendency to go back to the credit cards, and in short order, now you owe the $15,000 loan and your credit card bills are rising as well. So you tend to have this spiraling down effect of your debt. So that's one type of debt consolidation. The other type of debt consolidation is where you go to typically a nonprofit organization like a consumer credit counseling or something like that. And they then work up a budget where you pay them a monthly payment, and they then in turn negotiate with your creditors to typically lower the interest rate a little bit. And they take in the money every month, and they send it out to the creditors to make those payment arrangements that they've scheduled for you. The problem with those, and there's a number of problems, and we'll get into what the problems are, but the main problem is that, again, you're not really solving the debt burden. You're just you've reduced the interest rate, and we'll talk in a little bit about the fact that not everybody agrees to these, and there's a whole host of problems that cascade it, because you think you're solving all of your financial problems when you work with one of these entities. But it turns out that there's a lot of things that aren't resolved and that come up to bite you through the process.
Some of the consumer credit counseling programs here in Birmingham, there's a good one, as these programs go, that's sponsored by the United Way. And, on occasion, somebody will come to see me, and they may not really be in a position where bankruptcy is appropriate. Maybe a younger person that just has 1 or 2 credit cards. There are instances where I'll say you might want to try a legitimate credit counseling agency, but you're exactly right. In a lot of instances, they just don't address the overall problem. And then there's the companies that say they'll do the debt negotiation.
Right. So the debt negotiation is a different animal, and those are really where the late night TV ads get creative. Those programs essentially work where you go to one of these programs and you pay them a monthly payment every month, and they dump it into a bank account and wait for that account to grow to a point where there's enough money in there where they can then go to one of your creditors and try to negotiate a lower payoff for the account. So, and again, lots of things that are not disclosed during the initial sign up and marketing efforts that come back to bite clients. But in particular, there are significant fees that these companies charge for this service. So while you are dumping money into their bank account, they're taking their fees out of that. And in addition, the debt that you owe, the $15,000 in my prior example that you owed when you signed up with them, continues to grow until they approach them to negotiate that balance. So if it takes a year or more for that account to grow to a point where there's enough money in there to do the negotiation, when they then go to negotiate, they're not dealing with $15,000 worth of debt anymore. They may be dealing with $17,000 or $18,000 or $19,000 worth of debt, with the interest and late fees and penalties that have accrued while that account was rising. So, and again, we'll get into some of the other things that are left out of the discussion when people are being talked into that. But to your point about these programs overall, I agree completely. I would say that about close to half of the people that come into our firm, bankruptcy isn't the best answer for them. And so we do refer people to these programs occasionally, and well, not occasionally, even more than occasionally, but we do caution them to really seek out the ones that have good reputations, good reviews, and do your homework on these programs, because some of them are legit and work well, and some of them are just flat out scams.
And that's exactly right. Erik, you described the debt negotiation kind of model where they say they'll take your money and put it into an account and eventually negotiate. There's no guarantee that that money's sitting in any account or that they plan to negotiate. I tell clients, at least you and I as attorneys are responsible to state bar associations. We're responsible to the Justice Department through the U.S. trustee program, or bankruptcy administrator here in Alabama, or a federal judge. These debt negotiation programs really are not regulated in any significant way at all. And in fact, what we find by the time a lot of people come to see us, they've really wasted a lot of money with these type programs. And whether or not bankruptcy was necessary at the onset, it's certainly necessary by the time they get to see us, and they could have saved a lot of money by seeing us earlier. Is that what you see in California?
Every week. We see people. I mean, first off, I was featured in an article in the Wall Street Journal a few years back. I had a 76-year-old client come in who had paid one of these companies $26,000. And it turned out they never negotiated any of his debt. And when he went to go get his money back, it wasn't there. And so, like I said, some of these companies are just flat out scams, and it's really important to do your homework if you're gonna look at debt negotiation as an option for you. But yeah, go ahead.
No, I was going to say, and unfortunately, by the time you find that your money is not being used as you had intended, it's often difficult to track down these companies and try to recover your money. It's possible in some instances, but often it's next to impossible.
Well, you may find, like I do, Brad, that the people who come into our offices are really looking. First of all, they've really exhausted a lot of other options. Unfortunately, some of them may have liquidated retirement accounts and really burned through a lot of things that we could protect in a bankruptcy case. But in an effort to really, what they often say is do the right thing. But it's really in an effort to avoid bankruptcy, because bankruptcy is often, and as it should be, the last option that people have to pursue.
I want to just, if I can interrupt for a second, I want to just underscore the point you just made. People take money out of retirement accounts, whereas if they had seen you or seen me in advance, we could have advised them that money, while it's in their retirement account, is usually safe from their creditors and safe if they do seek bankruptcy protection. But once they take that money out, it's at risk and it's lost in too many circumstances.
And it's really hard when you meet one of the clients who've liquidated a significant 401k or something along those lines, because you know that you could have protected that, and that money was just effectively wasted.
I want to get to some questions we have for you here, Erik, but just to take a quick break here for people that may have tuned in late, I'm Brad Bodas with the Bond and Bodas Law Offices. My guest is Erik Clark with Borowitz and Clark in the Los Angeles area in California. Both of our firms help people with money problems. Both of our firms have experienced attorneys that have been doing this type work for many years. And both of our firms are offering absolutely free initial consultations at this point. Erik, I just had to confirm that on your website to make sure, but we are offering free initial consultations. And Erik, I assume you're also offering video or phone consultations at this point?
We are. In fact, what I tell my clients now is you can file bankruptcy from the comfort of your living room now. You don't have to come to our office. Everything's being done through email and virtual appointments.
And yet we're able to do it, we're able to do it just as efficiently and just as safely and with as much due diligence as we did when people were coming in. So there's no excuse, folks. If you're having money problems or if you see them in the future, reach out to one of our firms, whether you're in Alabama, Mississippi, or Tennessee. Bond and Bodas can help you, or in California, the Borowitz and Clark firm. We do these Facebook Live episodes once a week. We do them Wednesday at 1:00 p.m. Central Standard Time, and we try to touch upon issues that are impacting people during COVID. and that would be of interest to our clients and prospective clients. Last week, we did an interesting, kind of a tough episode on emotional issues related to debt problems and the issue of suicide. And we had Dr. Dale Wisely, who's an author and a licensed psychologist, to talk about those issues. Dale just wrote a book, 7 Stars Live, that is just an excellent short story to touch upon some of these issues. And if you know anyone that might be dealing with those type issues, I encourage you to go to our Facebook page. That video is available there, together with the other Facebook Live episodes that we've done over the last several months. But today, Erik Clark is here to talk to us about debt negotiation and debt consolidation, and some of the different ways that people are encouraged to either consolidate their debt or work with somebody to negotiate their debt. Erik is a board certified attorney. He has a lot of experience dealing with these type issues. I've been quoted by the Wall Street Journal and feels very passionate, as I do, about these issues. So, Erik, we're going to go into some of the questions that we have for you today. Are you ready to get started?
Let's go.
All right. So how, Erik, do these programs, and I want to focus really on the debt negotiation programs. The advertisements tell people avoid bankruptcy, stay out of bankruptcy, we can help you. How do they really work? Can they really lower your monthly fees and your monthly payments every month?
So the debt negotiation doesn't really worry about the monthly payments, because their goal is not to make the monthly payments. In fact, if you are current on your debt when you go in and enroll in one of their programs, they will tell you to stop making your monthly payments. So I guess in that sense, they've lowered it down to zero. Yeah. But
other than their fee.
Right, exactly. But you have to understand that, it's not rocket science. I mean, the companies that they approach to negotiate, if you're current on your credit cards, those companies don't have any incentive to negotiate on this debt. So you have to be delinquent, and the company has to start to believe that they don't have any chance of recovering any money on this account. For example, if you were to go file bankruptcy, to be in a position where they're willing to accept a reduced payment as a payoff. So what these debt negotiation companies are doing is they're collecting your money, they're letting it build up in that bank account I spoke about earlier. And then what they will do is they will typically go and approach the easier ones, some of which they may have prearranged arrangements with. So they know, for example, company XYZ, they can with a phone call get up and get those people to take 60 cents on the dollar. And so they do that because it can show you some pretty quick results and say, look at what we've done, look at what we've done, look at what we've done. But there are companies that won't negotiate. And so this is some of the things that you're not told about necessarily when you enter into these programs. So for example, medical bills, a lot of local medical hospital bills, doctors, things like that, they just simply won't participate in the program. And this is a really important point that I didn't mention. In both debt consolidation and debt negotiation, it is a voluntary process by the creditor. There is nothing that you or any of these companies can do to force them into a consolidation program or to negotiate the debt. They can simply say no, and some of them do. And there's large sectors of debt that simply don't participate in this type of process. So student loans typically won't do this. Medical bills, car loans, mortgages, taxes won't engage with these people. Judgment creditors that already have judgments typically won't do this. And court fines. There's a whole host of types of debt that just simply won't participate in the program. So as I was going to say earlier, Brad, most of my clients, and yours as well, come in and there's two things they want to do. They want to get the whole problem solved, and they want to get this all in their rear view mirror as fast as possible. They want to just get on with their lives. Typically, by the time they've come to us, they've been struggling for months, if not years, with these problems. They're fed up, they're exhausted, they're stressed out, and they just need to move on. And so these programs, these debt consolidation and negotiation programs, seize upon that sentiment and say, hey, we can solve your problem. But in reality, you can often only solve part of the problems to the extent they can even solve those.
You mentioned how these programs, and this is such an important point, are voluntary, and the creditors do not need to participate. And for you and I, for people that do seek bankruptcy protection, we know that bankruptcy is not voluntary for creditors. In fact, the very minute you or I file a bankruptcy petition for an individual, there's an order issued by the court. It's an injunction called the automatic stay, and creditors are ordered, all creditors, a very limited exception, but the vast majority of creditors are ordered to cease all collection activity immediately. So there's the power of the federal court behind a bankruptcy type proceeding. Erik, a lot of these companies say they're going to be able to get you out of debt in 24 to 36 months. How is that possible?
Well, it usually isn't possible. And so a lot of times when clients call me and they tell me they're in one of these programs and they tell me they're going to get out in the 24 or 36 months, I just simply break out my calculator and do the math for them and tell them it's not adding up. It's fuzzy math, to coin an old phrase. And so typically these programs will last anywhere from 4 to 5 years. And the reason why that's really relevant, Brad, is because the entire time you are in these programs, your credit is shot. Every single month, all of these creditors are reporting all of these accounts as delinquent because you are not paying according to the original contract terms. And if you're not paying according to the original contract terms, you are by definition delinquent on the account. So even though you're in a program doing your very best to pay it back, and even through debt consolidation where you're paying it all back, they are still every month reporting it delinquent on your credit. And so you have credit that you can't really do anything with for the 4 to 5 years that you're in the program. And then on top of that, you have to spend the 1.5 to 2 years to rebuild your credit. So through these programs, the truth is that they end up impacting your credit for anywhere from 6.5 to 7 years from the date you enroll in the program.
And often, in many cases, it's worse than a bankruptcy filing, even though they say they're doing it to help you avoid bankruptcy. Erik, you mentioned that a lot of creditors, car loans, student loans, tax creditors, medical creditors won't participate in these programs. So what does that mean if they won't participate? Do they just sit out and wait to the end of the program?
Oh, if it was only that easy.
Yeah.
No, it means that they are continuing their collection efforts alongside your debt negotiation or consolidation program. And the problems that creates is, first of all, it tends to eat into your disposable income, making your ability to pay the consolidation or negotiation fees very difficult. But what really happens as time goes on, is you get sued. I mean, so in the case of a car lender or a mortgage, you might be facing a repossession or a foreclosure. In the case of student loans, you're facing lawsuits. Taxes, you're facing levies and garnishments. So all of these other entities are still collecting their money. And the fact that they don't care that you're in a consolidation or a negotiation program, they are caring about what you're doing about them. And so that's, and even worse than that, Brad, and I'm sure you're aware of this, I see clients walking in who have been in these programs and are being sued by creditors that were involved in the program.
Right.
And they're sitting there shocked saying, wait a minute, I was told that this XYZ debt negotiation company was going to handle these people. Why are they suing me? And again, that goes back to the way the process actually works. Because as I stated earlier, the companies tend to go after the low-hanging fruit, the ones that they may have pre-approved arrangements with, and leave the bigger, more complicated negotiations to the end of the program. And those companies have been sitting there in some cases for a year, receiving nothing. And they eventually say, wait a minute, what are we doing here? Why are we waiting on this? Let's just go ahead and file a lawsuit, because again, nothing is preventing them from doing that. And so that is, as you stated earlier, when you say a lot of clients waste a lot of time and money in these programs, Typically what we see is they've been in the program a year or two, and then they walk into our office with a summons from a company that was involved in the program. And that's sort of the straw that broke the camel's back. And they come in, A, looking for explanations on how this and why this happened, and B, what other recourse can they take? Because it's now finally dawned on them that this was not the right answer.
And they've done everything this financial expert told them to do. They've made the payments as instructed. They've filled out all the forms. Nothing more disconcerting to see one of those individuals that wanted to do the right thing, and they coming and they're being sued or being garnished, or their car's been repossessed because they don't have the protections that were promised to them. You mentioned the impact on credit. Tell us about the difference in recovering from a bankruptcy as opposed to recovering from working with a debt negotiation or debt consolidation company.
Yeah, this, quite honestly, Brad, when I explain this to people, this is sort of one of those light bulb moments when people start to realize that the bankruptcy may be the right answer. Typically, you file so there's two different types of bankruptcy that individuals will file. There's a Chapter 7 bankruptcy, which is a process which most of your, if not all of your debt is going to be eliminated through the bankruptcy process. That process will typically last 3 to 5 months. And the day you file the bankruptcy case is the day that's the date that's put on your credit report that you filed the bankruptcy case. So that's an important date. We refer to it, as you know, as the petition date.
Right.
And so the petition date is the date that goes on. It's not when the bankruptcy ends, it's when the bankruptcy starts. And so I tell my clients, that's the day that you start rebuilding your credit. Unlike the 4 or 5 years that you have to wait to rebuild your credit through these programs, you start rebuilding your credit when you file bankruptcy in Chapter 7 on the day you file. And so it takes about 1.5 to 2 years to rebuild your credit after filing Chapter 7 bankruptcy, just like it takes to when you go through a consolidation or a negotiation program. The huge difference is when that 1.5 to 2 years begins. And again, with bankruptcy, it begins immediately. With these other programs, it begins 4 to 5 years down the road. And then there's one other, if I can just finish one last thing.
Please.
One other thing that has come to me recently is that your other creditors, all of the creditors that are getting paid in these programs or wiped out in bankruptcy, are also reporting on your credit report as well. And so when you go through a consolidation program, they are allowed to report derogatory information on your credit report for up to 7 years from the last date that they received a payment or when you incurred the debt. Well, if you're going through a debt negotiation or a debt consolidation program that lasts 5 years, well, then at the 5th year, they've finally gotten their last payment. Now that information will stay on there for another 7 years. So it's just the legacy that you have to deal with in terms of your credit report through consolidation and negotiation is much longer than it is through a bankruptcy filing.
There's a misperception amongst many people that consider bankruptcy. They think their credit's going to be ruined for 7 years or for 10 years, and they won't be able to get any credit. What I tell people is, you've been doing this for over 20 years, Eric. I've been doing it for over 30. We used to spend a whole lot of time helping people to rebuild their credit. Today, it's almost at the point where I have to advise people so that they don't get into the same trouble, because credit is easily accessible for a lot of our clients immediately after they file bankruptcy. And people ask why. Well, the day they get, there's the filing date, which is important, as you said, but on the day they get the discharge, which in a Chapter 7 is about 4 months after they file their bankruptcy, they have a court order that says they don't owe anyone else any money. And they can't file another Chapter 7 bankruptcy for 8 years. So they're a good risk at that point. We're one of the few businesses that doesn't really like repeat business. We don't want people to get into money trouble again, but it's not difficult at all, whether it's good or bad, but it's not difficult at all to get new credit these days following a bankruptcy compared to what it was 20 years ago.
You're absolutely right. And I tell clients all the time who are worried about getting a car that there are car dealers that will literally get them a new car the day after they file a bankruptcy case. It's not as difficult as it used to be. And you're right, the real challenge is to not get too much where you might get yourself back into a position where you're having some financial difficulty.
But the ability after a bankruptcy to get new credit also presents an opportunity to rebuild credit.
Absolutely. And so that's part of the bankruptcy discussion that we have. I mean, getting rid of the debt is part of the problem. But in a firm like yours and a firm like mine, we don't just file the case and leave the client and go, you're out. I mean, we really are talking about how life after bankruptcy needs to evolve. My tagline for bankruptcy really is rebuild your future. And that's really what this process is about. We're looking at the future. I'm not really concerned about the past as much because that's already happened and we can't control that. But we do have a lot of control over the future. And so as I stated earlier, a lot of my clients and your clients, I'm sure as well, their goal is to get this in their rearview mirror and get back on living their life to the best they can moving forward and not having to rely on credit to do that. And so filing bankruptcy is the first step. And then we counsel them on how to rebuild the credit and move forward in a productive way.
And I want our viewers to understand why it is so important to use an experienced bankruptcy attorney. Whenever there are economic hard times, a lot of new attorneys get into the bankruptcy practice. It's so important to go to somebody like Erik Clark that is going to be there in the long run, somebody that's going to be able to help you following your bankruptcy. Erik, we all know issues come up for many clients following a bankruptcy. You may have a creditor that continues to collect or continues to report something on your credit report. And there are things we can do to help our clients. But it's important to know that the attorney you use is going to be there a month after you file bankruptcy, a year after you file a bankruptcy, and into the future.
Absolutely.
Erik, what advice do you give to somebody that they want to avoid bankruptcy and they're considering using one of these companies? What kind of investigation should they do?
Well, I think, nowadays with you get online and check out the reviews, read through the reviews and read through both the 5-star and the 1-star reviews. Find out whether or not these companies have been involved. A lot of them have been involved in class action lawsuits, and find out why. But I will tell you that most of the time when clients do their homework and do their due diligence and put the three possibilities side by side, debt consolidation, debt negotiation, Chapter 7 bankruptcy, almost always Chapter 7 bankruptcy ends up being the best of the three options in order to be able to get this behind them and allow them to move on with their lives. Again, there are instances where consolidation and or negotiation and quite frankly, we do debt negotiation occasionally for clients who don't qualify for bankruptcy or may have assets that they don't want to have liquidated in a bankruptcy. Then we might go the liquidation or the negotiation route rather. But one of the things in all of the years that these debt negotiation companies have been around and been doing these advertisements, and all of the years that people have walked into my office having been involved in them, I have yet to meet the client who was told about the tax ramifications to debt negotiation. And I mean, it is stunning to me that not one of them, every time I inform them of this, they just claim nobody ever mentioned that to them. And what I mean by that is that if you owe a credit card $10,000 and that credit card through the negotiation tactics of my office or one of these debt negotiation companies agrees to accept, say, $4,000 as a payment in full and a lump sum payment in full, you're going to get a 1099 for the $6,000 that company agreed to forgive. And the IRS considers that debt forgiveness income, and that becomes part of your gross income for that particular year, and you pay taxes on that. Now, there are some exceptions to the debt forgiveness income tax, but I will tell you that I had a case recently where I thought one of the clients actually qualified for the exemption, but their tax preparer knew nothing about the exemption. Their tax preparer simply told them, if you get a 1099, you must pay the taxes on that. And so these companies seem to always leave that part of the equation out. And it's important that clients understand that, because otherwise you get a really difficult surprise when you're doing your taxes the following year. And so when you side by side then do the analysis with, you went in at $15,000. By the time they negotiated the debt, it was $18,000. They may have settled it for half. And then you add on the tax ramifications for it, the fees you paid the debt negotiation company. What you really get at the end of the day is you paid pretty much all of your debt, had your credit ruined over 5 years, and still struggling.
I was about to ask you, I'm glad you covered that issue, because one of our viewers had asked about the tax implications. What's even worse is if after that you do decide to seek bankruptcy protection, that new tax debt's not going to be dischargeable, at least not for a period of time.
Right.
We've talked about comparing these programs to Chapter 7 bankruptcy. We talked a little bit about Chapter 13 bankruptcy and how it is. It's a type of repayment program in itself. It's a personal reorganization. I always tell individuals it's similar to a corporation, an American Airlines, a big corporation doing a Chapter 11 reorganization. But what would be some of the differences between a Chapter 13 debt consolidation plan and a debt consolidation or debt negotiation plan with one of these programs, Eric? What would be some of the differences?
That's a great question. And when I get clients who may not qualify for Chapter 7 and I start talking about Chapter 13, and even in a case where they have to pay back all of their credit card debt in a Chapter 13, their question is, well, why would I do that? Why wouldn't I just go through debt consolidation? There are some really fantastic answers here, and so let me go through them. One is, again, as we stated earlier, in these debt consolidation negotiation programs, the creditors don't have to participate. In a Chapter 13, we are on, and it completely upends the balance of power between the debtor and the creditor in a Chapter 13. Because until you file bankruptcy, your creditor holds all the cards. They can change the terms of the agreement. They control the terms of the agreement. They control everything and all of the discussion. But when you file Chapter 13, we now control the dynamic of that relationship. And I often tell my clients inartfully, we're not asking for their permission anymore. We're shoving this payment plan down their throat, telling them to sit down, be quiet. You're going to get paid, but you're going to get paid on our time frame. And so we also often, we eliminate the interest on the credit cards. And so what ends up happening, Brad, is that a client is able to pay off their credit card usually in full over 5 years for at or less than what they're already paying on the minimum monthly payments. But keep in mind that the minimum monthly payments on a credit card is a 30 to 40 year long repayment plan. So when you start to do the math, that we've lopped off all of these years of these payments, the savings are enormous. And I often tell the client, this becomes a no-brainer at that point, because we can get you back to zero. In a worst case scenario, in 5 years, we can get you back to zero, where after 5 years of making your current payments, you still have 25 years to go. So it's just a tremendous program. And then there's also what I call the lottery component to Chapter 13. And what I mean by that is that your general unsecured creditors, things like credit cards and medical bills and lawyer bills and things like that, they have 70 days from the date of filing the bankruptcy case to file paperwork with the court in order to get paid. And if they don't file the claim, they've lost their right to get paid, and they get wiped out just like it was a Chapter 7 bankruptcy case. And I would say that in the overwhelming majority of our cases out here, creditors, there are certainly some claims that do not get filed. I have had cases where 90% of the unsecured creditors did not file claims. Those are rare, but it's equally as rare where all of the creditors file claims. So you are likely to eliminate some debt, even if you don't qualify for Chapter 7, like you would in a Chapter 7 through Chapter 13. But it's just a much more powerful tool than any one of these other alternative programs. And it also allows you to just resolve this in a much more calm manner. You make a payment every month at a bankruptcy court. You move on with your life. The whole thing gets cleaned up. There's no collection calls. There's no lawsuits. There's none of the nonsense that happens so often with these other programs occurs.
And just to add to that, everything is overseen by a federal judge and a federal trustee, including our fees, including your attorney's fees.
Yes.
We have to be fair. We would be fair with your fees, but everything is overseen by both a judge and a trustee to make sure you're treated fairly. There are not going to be any tax implications because when you discharge that debt or that interest through a bankruptcy, it's not a taxable event. Just a host of benefits if you do want to consolidate or you do need to consolidate your debt for some reason, to doing it through a Chapter 13 bankruptcy, which could last as little as 3 years and up to 5 years. But at the end of that period of time, your debt's going to be addressed. You're going to have a discharge and a fresh start that's guaranteed by the bankruptcy code.
And one other note on that, as I stated earlier with these other programs where you're only resolving certain segments of your debt problems, Chapter 13 will take care of it all. It's all, whether it's mortgage arrears, car loans, taxes, court fines, whatever, it all gets wrapped up and resolved through Chapter 13. Now you may have to pay some of the debts that aren't the kind that can be wiped out in a Chapter 13, but it is a global solution to your problems as opposed to a piecemeal approach.
It's great being able to steer somebody that's had money problems through either a Chapter 7 or a Chapter 13 program, because we can stop all of the collection activity, we can do it quickly, and we can get people on the road to a fresh start. I want to break for a second here. My name is Brad Bodis. I'm with the Bond and Bodis Law Offices. We do these Facebook Live episodes weekly to help you learn about financial matters that may affect you, may impact you moving forward. If you know people that you think might be impacted by the issues we discuss here, please refer them to our Facebook page. All of these episodes, including today with Erik Clark, is stored on our Facebook page and is available to be viewed later. My firm, the Bond and Bodis Law Offices in Alabama, Mississippi, and Tennessee, and Erik Clark's firm in Los Angeles and the surrounding area, we are offering absolutely free initial consultations right now. We will do them by phone or video from the comfort and safety of your home or office. And as Erik said earlier, we can actually handle the entire bankruptcy process if that's the best step for you by phone or video. In fact, Erik, some of the folks have a hard time coming in to see you or me about their money problems, but it's even more difficult for them to go to that one court hearing they may have to attend. When I tell people even that court hearing now is done by phone, I assume they are in Los Angeles too. It's a relief, and it's a way to get through this process at this time safely. Erik, I want to thank you again. We have had a couple of questions come in here that I want to address. So, important question here. What if I'm already in one of these debt negotiation programs? How do I get out of it? How do I cancel it?
You can do it in a number of ways. The easiest way is just stop paying them. Often they take their money through an automatic withdrawal from your bank account. So I often recommend to clients that they close that account and open up an account at either that bank if they don't owe that bank any money. We always tell clients that they shouldn't bank at a bank where they owe money. So we'll tell them to close the account. Some of these companies, you can call them up and they'll be fairly good about canceling. Some of them will say they're going to cancel it, but they just mistakenly pull another payment or two. The real question here is, are you entitled to any of the money on the debt negotiation companies that you've put in if you call up and cancel? Because they, in theory at least, have an account sitting there growing with your money in it. And we've had mixed results. I mean, we've had some clients, like I said, that 76-year-old man who who lost out his $26,000. We've also had other people who get their money back minus the initial fees that the companies charge. But you can simply stop paying them is the easiest one. Call them, submit something in writing to them that says that you're canceling their services. But I tell all of my clients, close the bank account that they have access to. There's been too many instances where they continue to pull the money in spite of saying that they're going to cancel the fees, or they just refuse to cancel. So close out the accounts. And then what we'll do is we'll list them as a creditor when we turn around and file the bankruptcy, just so that they're on notice that they can't even contact you.
And our process is somewhat similar. We absolutely encourage them to close the account that the money is coming out of. I ask them to document the cancellation in some way. If they do it in writing, perhaps do it by certified mail. If they do it by phone, make a record of the name of the person, or at least the name given of the person they talked to, the time, the day. Create as good a record as you can. And then what's important for people to know with respect to getting money back, firms like Erik's and firms like Bond and Botus, if we decide that bankruptcy is the best route for you and we move to obtain bankruptcy protection for you, in a lot of instances, we can make an effort to get a lot of that money back that you paid to that company. Without going into too much legalese, Erik, sometimes those payments are a preference. They're large payments made before bankruptcy that we can exempt and get back for you. Other times we can assert rightfully that the money was taken from you via misrepresentations or fraud, and we can try to get that money back. And that is the advantage of using a board-certified attorney like Erik Clark, somebody with experience in these areas, rather than somebody that's just going to quote you a fee and get you through the bankruptcy process quickly. Bankruptcy is an important process. It's something you only want to do once in your life. It's going to impact you in a lot of ways. It's not something to save money on. Erik, I don't know about you, but we get a lot of calls from folks these days just wanting to know how much it costs to file bankruptcy. And my standard response is it costs a lot less to do a bankruptcy right in the first place than to fix a bankruptcy that was done wrong. Using a board certified attorney like Erik Clark, I'll add that I'm also board certified, and Ron Sixtus with my firm is also board certified. We're two of only about 5 or 6 board certified consumer attorneys in the state of Alabama, Erik. Using an attorney with experience in this area, you're going to have a good chance of getting some of that money back from these debt consolidation type companies. So don't be embarrassed about it. Schedule your consultation with our firm or with Horowitz and Clark and talk to the attorney about what's happened to you. Erik, you said in some instances you've been able to get some of this money back for clients. Similar circumstances to what I've described. Is that how you've done it?
Yeah, I mean, look, the last thing these companies want to be is in court defending their business practices. So typically, when you're trying to get the fees back, they tend to be fairly agreeable, especially if they were taken recently. But some of them actually have settled some of the debt and they've done some work, and so they may be entitled to some of the money. So it's always a case by case analysis. On the note though, with regards to a board certified bankruptcy specialist, one of the analogies I often use when talking about bankruptcy with clients is that bankruptcy from a distance is sort of like a minefield. And if you look at across a minefield and it's all just beautiful green, freshly mowed grass, and it looks like anybody can run across that field and get to the other side. And there may be 1,000 people that get on one side and everybody's going to run across at the same time. And like in any minefield, what's going to happen is some people are going to get through the other side unscathed. Some people are going to get through the other side having blown up and lost a limb or something along those lines. Some of them aren't going to make it through the other side.
Right.
And so a board certified bankruptcy specialist is someone who knows where all the mines are buried and knows how to avoid the mines before you ever step into the grass. And so attorneys like yourself and myself, and the people who work at our firms, we've seen it all before, and we know the issues that can get people into trouble, and we know how to avoid them. And that's really the best way to go through bankruptcy is without those issues. We can solve those problems before we ever file the case.
I'm always comfortable enough, Erik. I tell people most of us offer free initial consultations. Interview a couple of different attorneys. I want you to feel comfortable with me. I want you to feel comfortable with my staff that you're going to be interacting with quite a bit. I want you to feel comfortable with the environment that you're in when you're dealing with our offices. I know you have an excellent staff there in Los Angeles, and I know you take good care of your clients. Erik, before I finish up, I want to give you a chance to, if there's anything else about the debt consolidation or debt negotiation business that I may have missed here with my question, and you'd like to talk to it, please go ahead.
I think we've covered most everything that I think people need to know. Again, it's not an industry that is completely without merit, but it's good for the right people. And unfortunately, the majority they sign up a whole lot of people who shouldn't be in these programs. To be quite frank, these are people. I mean, they're not sitting there talking about the virtues of bankruptcy. As compared to debt negotiation when you go meet with them, as we are when we're talking with people about bankruptcy, talking about these programs. It's important for anybody who's thinking of consolidation or negotiation programs to really explore your options. As you've stated several times, Brad, we all offer free consultations. Come in and meet with us, make a phone call. We do ours by phone right now because we're all under lockdown here in California. Call us and let's discuss these programs, and then go meet, if you really want to, with the debt negotiation and consolidation companies and hear what they have to say. But it's been my experience that the overwhelming number of people, when they do their homework and they do their due diligence and they stop looking for the magic wand approach, realize the bankruptcy, when all three of these things are lined up side by side, often just screams off the page as the best answer to get out of this financial difficulty for the least amount of money, as quick as possible, to get back on track with your life and do the things and pay attention to what you really want to pay attention to, which is your family, your work, and enjoying your life, rather than cringing every time the phone rings at the house from a collection call.
The anxiety that COVID and financial issues combined has caused for people it's very difficult. And reach out, be proactive, talk to people, get advice, but do your due diligence. Real quickly, we have a question that came in through Facebook from Colin, wanting to know, Colin's in a Chapter 13 bankruptcy now, paying a percentage of debt, and wants to know if there are going to be tax consequences at the end of the Chapter 13. I'll let you go ahead and address that.
Okay, so there shouldn't be. There is, again, as I mentioned earlier, there are exceptions to this debt forgiveness provisions in the IRS code. One is that you are insolvent when the debt forgiveness arose. Bankruptcy gives rise to a legal presumption of insolvency. So if anybody were to tell him that there are, he needs to talk with a tax preparer, a CPA, who's well-versed in these issues about debt forgiveness. Again, as I stated, so many of them are not tax preparers who just believe if you get a 1099, you've got to pay the tax debt. It's just not the case, especially in a bankruptcy scenario. And so the answer is there should not be any tax consequences at all unless there's something I'm unaware of.
And Colin, most importantly, yes, you can reach out to to an accountant, to a qualified tax preparer, but reach out to your Chapter 13 attorney. If you're one of my clients, I'll tell you, as long as that you receive a discharge at the end of your Chapter 13, there should not be any tax consequences. And again, the benefits of using an attorney like Erik Clark to take care of you with financial matters, somebody that you know and that's been around and can be trusted. To all of our viewers, thank you for listening in today. Again, all of these episodes are available and stored on our Facebook page. If you know somebody else that might benefit from this, or if you want to go back and listen again later, please feel free to go to our Facebook page, Listen to the great advice given by my friend Erik Clark. Erik, thank you so much for participating today and sharing your knowledge. We appreciate it.
Brett, thanks for inviting me. This has been fun, and it's good to see you.
Good to see you. And on behalf of Erik and the folks at Borowitz and Clark, and on behalf of myself and all of us at the Bond and Botus law offices, be strong. We're going to get through this together. If you need help, reach out. We're here to help you. God bless and good luck going forward. Thank you, everybody.
Thank you.